Dennis O'Rourke.
Mr Speaker, New Zealand First originally supported the Register of Pecuniary Interests of Judges Bill because some cases in recent years appeared to indicate that legislation would be necessary to ensure transparency in respect of judges' interests and to provide a solid means to ensure avoidance of conflicts of interest. And I think it's important that we note the principle that people involved in decision making, whether that be in the judiciary or politics or in business, need and who make decisions in the public interest, need to be prepared to give up a degree of personal privacy so that the public can have confidence in conflicts of interest situations which might arise. And in my first reading speech, I said that we needed to show an effective means of avoiding conflicts of interest for judges, and that I couldn't see how really that could be achieved without legislation. However, having participated in the select committee process and having heard the submissions, including written submissions from the judges themselves and submissions from several others, especially the Law Society and the Bar Association, I now think differently. And New Zealand First will not now support the bill. Nevertheless, I do wish to commend Kennedy Graham for promoting the bill because his concerns about the situation were certainly justified. And the process of considering the bill has led to greater understanding, not just amongst MPs, but many others in the community as well. Most particularly, the judiciary has moved to beef up its procedures in respect of the recusal of judges, since Justice Wilson failed to recuse himself in the Saxmere case. So in those ways, the bill has already been a considerable success, and the fact that it is now unlikely to pass doesn't detract from that. Mr Speaker, the current law on whether a judge should sit or not on a case due to apparent bias has now been clearly stated in the Court of Appeal in Saxmere, and I quote as follows: "A judge is disqualified if a fair-minded lay observer might reasonably apprehend that the judge might not be able to bring an impartial mind to the resolution of the question the judge is required to decide," unquote. So the law, at least now, is clear. But Parliament still needs to be satisfied that the processes for recusal are robust and that, in fact, a register of judges' interests is not now needed. And as other speakers have said, the Law Commission issued a paper back in 2011 on this, and it recommended that such a register not be legislated for because it felt that it wasn't the best solution to deal with conflicts of interests issues. And Mr Speaker, the central issue is that the public must be satisfied that the judges are deciding cases in a way that is fair and impartial. And if a judge does in fact have a pecuniary interest in the outcome of a case, he or she must automatically be disqualified from hearing it. And where there is doubt, there is a duty on the judge to disclose that to the parties present, to invite their comments, and then to make a reasoned judicial decision. Failure to disclose a conflict of interest will, of course, amount to misconduct and no doubt a complaint to the Judicial Conduct Commissioner. The Court of Appeal has itself adopted an internal protocol for managing potential conflicts. So I think that when you look at all of that, we can conclude that there are indeed very robust requirements which the public can have full confidence in. The existing law, the appeal processes, the guidelines for judicial conduct, the bench protocols, as well as the judicial complaints process, in my view, are clearly sufficient to address any conflicts which may arise, and that therefore a register of pecuniary interests of judges is now not necessary to achieve the object of fair and impartial judges, not tainted by personal conflicts of interest. But there are several other good reasons as well for not having such a register, and the submitters listed several of those, and some of them are these. First of all, that there would be a serious risk to judges' privacy, that there would be scope for abuse of information disclosed by judges. A register could result in intrusion into the personal affairs, not just of the judge, but of the judges' families, and could create opportunities for harassment by disgruntled litigants. And I agree with the Attorney General on that issue, that there are many who are disgruntled and will find ways of expressing that. And I'm sure that if there was a register, they would use it for that purpose without any hesitation. In addition to that, there would be a significant administrative burden which would accompany a register and its maintenance, and it might also cause delays in hearings which would otherwise be avoidable. Most particularly, I think there was a real risk that the ability to recruit and retain judges of a high calibre could be compromised if they saw that they had to enter into a register of pecuniary interests in the way suggested. So, Mr. Speaker, in the end, while the idea of a register of pecuniary interests for judges was well worth investigating, that having been done, it's clear that such a register is now not necessary, and that it in fact does have some significant downsides. So on balance, Mr. Speaker, New Zealand First will not be supporting the bill because we don't think it should be passed, and we feel that those provisions that are already in place for recusal, which have been upgraded and improved in recent times since the Saxmere case, are actually sufficient and nothing further is needed.